Hello. I know this is the end. I mean, everybody's kind of tired, so we won't say much, I think, but we did want to say a few words, and Mikhail and I were kind of deciding who would go first, who would go last, and I don't know who won, but in any case, I'd like to thank all of you for your presence. I also wish to add my thanks to Daniela and Nofar for making the miracle of this gathering possible. We all owe them a very felt debt for bringing us together. I think students always give us a relation to the future then, this event as a sign of Daniela's and Nofar's energy, commitment, thoughtfulness, and grace, offers us a glimmer of hope for this future, a glimmer for which I personally am very grateful. So thank you. I want to thank again all the departments, centers, institutes, and units across the campus that co-sponsored the event. I want to thank everyone who so kindly moderated our panels, and I especially wish to thank all of the participants for their time and generosity, and for the opportunity to think with them about the questions raised by this conference. I've always found the work we do, the special heaven and hell of the reading and writing, rather lonely, sometimes isolating, and what nevertheless has confirmed me in the madness of doing it has been the chance of having people I love and care for with whom I can talk about what matters to me and what matters to them. And it's in this context, a context in which we've all perhaps had a chance to speak about what matters to us, that I would simply like to thank everyone whose presence has enabled this event. Having said this, I want to begin by confessing it's perhaps impossible for me to make these closing words. And not only because the questions opened these last days cannot be closed, but also because each of the talks has had its force, its logic, its singular strategy, which means that if I were to address everything that has been said, it would be necessary to reread everything, to reconstitute each talk and its trajectory, the themes and arguments of each, the discursive traditions and the many texts they set to work, and this only to begin. This is why every invitation to make such remarks must always simultaneously leave us free and take us hostage, us to take a certain liberty and bind us to a certain responsibility. I will simply ask forgiveness if I'm unable to respond to everything you might wish me to, even as I try to follow, like a kind of red thread, the motifs and issues I believe circulate through most of the presentations. Those of the assertion and dissolution of identity, the relation between self and other, the role and place of race, memory, trauma, and language in the construction of historical and legal understanding, and the relations among law, history, and politics, but in relation to three neuralgic points. First, the eyes, ears, mouths, and noses that suggest the role and place of the body within the law, but also the way in which the law traverses the entirety of our body and not only its parts. This is already to say that the law has to be thought in its materiality and embodiment, that it is not restricted to legislation, rules, and texts. It involves the eyes that look at evidence, the ears that hear testimony, the mouths that chew the body of Christ, or the nose that, like Nietzsche's bloodhound, sniffs out decay, degeneration, the smells of cities, and the crimes of morality. But these organs are never simply themselves either, since their functions are neither entirely physiological nor entirely functional. This is to say that they're beyond the paper principle and a beyond the body principle at work within the law, and without which it would not be what it is. It would not extend. First then, the law is everywhere. Even when it appears through other means, even bodily means that in the end refuse to be entirely other. This acknowledgement requires a reconceptualization of the law and a thinking of where it is and where it isn't, or where it is even if in another guise. Second, the way in which objects are never just objects, but rather archives of an entire network of historical relations, of unforeseeably mediated relations, just like each of the senses. I appreciated the ways in which several talks sought to reconstruct these relations, these histories, from the objects before us, from the aleatory memories of sensations, and in doing so suggested a relation between objects and humans, between objects in human history and memory, something that also in other talks moved almost in reverse, from memory to the reconstruction of objects and even buildings, from memory to the architecture of memory or sound. Third, if the law is ubiquitous, if it touches everything, if nothing escapes it, then what is at stake is an understanding of the essential interdisciplinarity of the law, something that prevents the law from ever being identical to itself. Perhaps what makes the law is that it can never be simply itself. What was so remarkable about the range of all the talks we've heard these last days is that each one opens the law to its presumed others. Art, history, philosophy, psychoanalysis, sociology, anthropology, religion, economics, ethics, literature, gender and sexuality studies, media, and politics, and shows that the law, always inhabited by these others, can always only exceed itself. As a consequence, and in relation to the question of synesthesia in particular, it is in the oscillation among the senses, in the coupling of seeing and not seeing, hearing and not hearing, speaking and not speaking, touching and not touching, smelling and not smelling, and the human and non-human, that responsibilities form. And indeed, as Jean-Luc Nancy would have it, where certainties come apart, there too gathers the strength that no certainty can match, end quote. There would be other threads to follow, of course, but I trust that Mikhail can supplement what I've said here. Now I want to gesture toward a close by returning to our beginning, the opening panel with Brad and Pat, and in particular, I too, as Bernard did, want to recall Pat's thematization of her inability to respond to one or two questions, especially in relation to the repeated death and violence to which she had referred in her talk, to the cries of anguish and anger heard in the video she and Brad recalled to us, to violence that cannot be reduced to subjects and agents. This inability, which she referred to as a kind of collapse in the face of the madness of what has been happening, is something that I have written about before and I have suggested gives Pat, like Kafka's sirens, a more fatal weapon than the song of her voice. And that is her silence, a silence that gives her writing its paradoxical rigor, a silence that is at once the space into which she writes, what calls for her writing, what calls for her thinking, and which she cannot keep in her writing. Cannot because silence, as her writing makes clear, cannot be kept, because writing, like speaking, can break the silence that always surrounds it, as it did for all of us Thursday evening. Still, Pat's inability to respond enacted a mode of silence that in this instance enabled her to resist reducing the experience of seeing and hearing the shooting of black men to a single statement or sentiment, to resist the danger of imagining or believing that we have a clear sense of things, and more generally to resist betraying the dead and the several silences that still today envelop them. Weaving together accounts of the many silences that work to efface or erase the violence of racism, the blind aggression of the police, the muffled sounds of strangled voices, the silences of complicity, Pat repeatedly has sought to conjure these forgotten and unrecorded struggles, to remain faithful to this history of silence, to write within this zone of silence in order to awaken the desire to respond, even in the face of not knowing how. What this silence evokes is a world that is both opened and closed, not only to many laws, but also to what cannot be assimilated to any familiar concept of law, to another law, and to something other than law. But it is because everything is touched by the law that we must make several complex gestures to signal that despite this contact or complicity, we are acting in this way because we believe this action, this reading, or this analysis is in this instance more likely than another to accomplish what we want, to interrupt the identities, calculability, rationality, instrumentality, and modes of transmission without which legal institutions could never secure their future. These gestures should not be understood as pragmatic resolutions to given situations, or much less to the fact that it is perhaps in the questions concerning law and the senses that the most decisive confrontations over our future are taking place. They are strategic evaluations which, in the face of uncertainty, nevertheless attempt to respond to the contradictory and invasive system we seek to unsettle at any given moment. This means that our most urgent and serious responsibility is perhaps that of trying to evaluate which is the least dangerous of these forms of complicity, and to do so even as we know that this effort can never escape the danger we seek to overcome. It is because whatever we do will remain insufficient that we remain in danger. There would in fact be no danger if it were not able to persist, to remain, and to haunt our every move. Perhaps danger is even what grants us our right to thought, to politics and political action. What the talks we've heard these days have called for in the face of this danger, from this danger, is a reconceptualization of the relation between law and its others. All the fields from which we cannot separate it, which intervene in it, and which cannot be said to be simply fields. It would call for new experiences of communities, frontiers, and identities without models, and perhaps even without laws as we generally have understood them. Laws of tomorrow that would match a democracy that is still yet to come and yet to be imagined. Several of the talks have gestured toward this democracy by asking us to invent laws anew, to invent a discipline that would be open to the future because it would be open to its own alterity. The emphasis on law's relation to the senses, and to never just one, asks us to reread an entire lexicon of the law. Autonomy, sovereignty, the state, freedom, choice, testimony, evidence, contract, nature, rights, jurisprudence, property, authority, authorship, equality, marriage, community, decision, self, person, human, citizen, stranger, pain and injury, torture and terrorism, death, mourning, and justice. And over these last days has prompted a wildly different set of presentations, and the differences among them is simply one sign among many of the richness of what synesthesia gives us to think. I thank all of you for taking up the charge of this conference, for responding to it, by seeking to remain faithful to it, by betraying it in order to be faithful to it, and by inventing and offering the gifts you have all given us. Thank you.
Thank you very much. So this makes my last words much more complicated because I'm going to be much more mundane. I didn't schedule it, didn't prepare a speech, and even if I would, I wouldn't be as interesting and that you were just, Eduardo. So the first thing I'm going to do is just, I want to convey, you already thank everybody for this wonderful event. Just want to convey the thanks of Sciences Po for Princeton, and Princeton is here a name for every center, department which participated to this. We're really, really very happy of this cooperation, really willing that this will have a future, and very thankful for your great hospitality. The second thing is, we're doing that for now 3 days, but I really want to personally thank Nofar and Daniela. You were saying that graduate students are the future. I must say, yes, but these are not ordinary graduate students. I must say it's the first time in my whole academic life that I can see graduate students taking the initiative of building such a conference with such an amazing success. So yes, graduate students are the future, but you're really extraordinary graduate students, and I want really to thank you for thinking ahead and being able to gather all of us and joining you in this thinking ahead. Concretely, I must say that I guess that many of us had the experience when we were invited here to first check what synesthesia means. Kendall, you will join me on this, I guess. And when I'm saying thinking ahead, I mean really. I guess that the result is really challenging, really interesting, and provides many avenues for trying to think forward. But it's not an easy result. And the way I understand these 3 days is that many ways of understanding the linkage between synesthesia and law are not going in the same direction, actually, which is great, by the way. That would have been terrible if everybody had came up with the same ideas. But these are, if we're talking about the future of this initiative, the potential many futures, I can see at least 3 trends that are actually very different. One is many of us talk about how law is structuring the senses or managing the senses, how law deals with smell, odors, taste. That is a trend. There's another one which is how law itself senses. The smell of law, the music of law, the rhythm of law, that kind of discussions. Actually a very different discussion. And I see a third one, which is how the sensible, the synesthesia, is actually structuring the law. So, Kendall, you were talking about a synesthetic logic of the precedent of the Supreme Court a couple of minutes ago. Many people suggested that actually there's maybe the sensible is a kind of originary background from where the law is, that is a condition for the law to exist. So I have this impression that it would be a mistake to choose. I have the impression that although all these are very, very different types of study and different projects, one of the interests of the 3 days was precisely the fact that sometimes we were wondering, are we talking about the same thing here? And obviously not, but nevertheless it produced interesting effects. So I wouldn't, the fact that I'm trying to separate them doesn't mean it's not a call for choosing, but rather a call for continue to try to keep that together. There's a fourth element that seems to me very important. You already emphasized that under the label of interdisciplinary thing, but ways of speaking about this connection between synesthesia and law, I mean, that was so diverse and so many different languages were brought from art to more classical academic work, art disciplines, because even where we're trying to doing interdisciplinary work, we still belong to disciplines somewhere. I mean, it's not as easy to be in disciplines or supra-disciplinary. And I must say here that, it raises the question, so is it possible to talk a bit, Bernard is not here anymore, but he was talking about Nietzsche. Is it possible, or is it how useful it is to talk about the law from outside the aesthetic ideals? So how much synesthesia is actually an invitation to talk about the law from somewhere else than the ordinary academic position? And I must say, it seems to me that when we enter in that kind of enterprises, obviously these are about crossing perspective. And when one started crossing, there's always the risk of an accident. I guess all of us felt during the 3 days, from time to time, irritation. What is that? Really don't understand what it is. Maybe more crude judgments like, that's bullshit. And I think that it's part of the risk. And it's extremely interesting that Daniela and Nofar asked us to take this risk. And I also think that these crossings allowed extraordinary encounters. So, for example, you were just, Emmanuel, you were just saying that, wow, art in an academic, so that produces that obliged us from time to time, not always, of course, but when it happens twice or 3 times during 3 days, that means the conference was a huge success. a kind of dissentement from the way we would have thought about that. I find this extremely productive, and I really wish that this productivity got a future. So last, it seems to me that we got a lot of questions unanswered at the end of this conference. One that I care about and I'm still struggling with is synesthesia critical as such? I really don't know. And I was discussing that with Bernard at lunch. I don't want to speak for him, but my intuition is that he doesn't know either. So that if Bernard doesn't know, it must be really open. So I wish we could continue to think about that. So bringing synesthesia in the discussion about the law, what does that produce exactly? Is that as such and in itself critical? How should we bring it to make it critical if it's not the case that as such and per se it is critical? Maybe now the second step would be not only synesthesia, but ways of speaking about synesthesia and ways of thinking about synesthesia against other ways that would be less critical and less interesting and less productive. So I guess that's the second step is about now trying to be more specific about synesthesia. I think that I'll stop here. And again, I want to thank you, Daniela, and Nofor for that. Thank you. Thank you very much.